Please proceed.
Thank you. Madam President, Your Excellencies, may it please the Court. As earlier introduced, my name is Genevieve Wu, and I too act on behalf of the respondent, the Republic of Romania. I will continue the case for Romania on the third and fourth prayers. Beginning with the third prayer, the contention is about where the applicant's exclusive economic zone, or EEZ, is. And this turns on the question, as put by the International Law Association in their 2012 Sofia report, whether the baseline is a line on the chart or a line on the ground. In other words, whether the baseline follows what is illustrated on the chart, officially recognized by the coastal state, or it follows physical reality. Now, the applicant has submitted that it is the former for the specific context of states preserving their zones in light of climate change. And they do so on three bases. First, that this is supported by the object and purpose of the convention. Second, by an evaluative interpretation of the convention. And finally, by subsequent practice informing the treaty interpretation. And I will disprove each of these elements in turn. Starting first with the object and purpose of the UNCLOS, it is clear that the convention was meant to create a stable regime for the law of the seas, but stability that is reached by a compromise struck by states parties to allocate their maritime rights to the extent that their land territory and their coast extends. In other words, the land dominates.
Counsel, sorry, if I could just back you up a little. So you've indicated that you're going to start your argument with the object and purpose, but could you start instead with the text of Article 5 and help us to understand how you interpret that in light of the other considerations that are relevant, please?
The text of Article 5 shows that the chart recognized by the coastal state plays an important role. But what it does not say is whether the chart determines the baseline or serves some other function, like evidencing where the chart is. So the text is ambiguous in itself. And that is why this court, to understand the text, has to refer to other elements of treaty interpretation in Article 31 of the VCLT, including the object and purpose. The object and purpose closely relates to the fundamental principle that the land dominates the sea. In other words, it is the coast that is the source of the maritime rights of the state, and this principle has been repeatedly recognized in these courts.
I would like to ask you a hypothetical question. Let's assume there would be a volcano eruption on the coast of a state that has submitted a chart. And this volcano eruption would result in 400 meters of additional territory to that state. Where is the baseline? The chart or the new territory?
The baseline would follow the new deposed territory that has been added. And I know this also pertains to a question raised by Madam President about situations where rather than land receding, land might be added to the territory of the state. And we submit that the position to be taken that is principled and consistent is for, in either situation, for the baseline to follow the physical reality. So if the land moves in, the baseline moves in. If the land moves out, the baseline moves out. This was also recognized as a consistent position by the ILA in their Sofia report. And this is also consistent with this court's jurisprudence, where it has looked behind the charts deposited by the state to determine the geographically accurate coastline of the state. As, for example, it has done in its 2007 Caribbean Sea decision between Nicaragua and Honduras, as well as the 2001 maritime delimitation case between Qatar and Bahrain. And because this is a long-standing position of the UNCLOS, what the applicant is suggesting that there is a permissibility for the fixing of baselines, and such a deviation from that long-standing practice will go against the object of preserving stability and certainty, where states knew for so long that all they had to do was to look to the physical reality.
Council, how would you reconcile your position with the principle of permanent sovereignty over natural resources, which is inherent to the right of self-determination, which has been recognized as a peremptory norm of international law? So the stability of maritime areas, which allows the applicant to continue exploiting the resources that are in its exclusive economic zone, is consistent with that principle of permanent sovereignty over natural resources. How would you reconcile that with your position?
It would be consistent insofar as the entitlement of the applicant to natural resources within 200 nautical miles of its coastline has not changed. It is entitled to that same amount. But that is quite different from saying that the applicant can continue to assert entitlement on an EEZ that no longer belongs to it, but belongs to the high seas for every other state to fish on the natural resources. And this is quite similar to how the idea of historic rights is something that is not codified in the UNCLOS, and as made clear by the Permanent Court of Arbitration in their 2016 South China Sea case, that principle of historic rights is overridden by the allocation of rights based on zonal systems like the EEZ in the UNCLOS.
Council, if we go back to Judge Nolte's hypothetical, think about that. A new peninsula is created. That's one scenario. Another scenario, more relevant to this case, the land mass shrinks. The state prepares new charts and submits the new charts to the United Nations that correctly, let's just assume correctly, indicates the low water line. Shouldn't those charts be given relevance? They're accurate, they're reliable, hypothetically available, informative to the world. Why isn't that the way forward?
I'll address those several points in turn, Madam President. First, to get to the relevance of the chart, we do not submit that a chart is completely irrelevant. They are important as presumptively accurate evidence of where the chart lies, or where the coastline lies, my apologies. But that is quite separate from saying that the chart is the be-all and end-all of where the baseline is. That is made clear by the Travaux Préparatoires, where when drafters stated that when it is proven by evidence that the chart is inaccurate, then it is subject to challenge by another state before a court or tribunal, as mentioned in, for example, the 1954 and 1952 fourth session of the ILC at pages 171 to pages 178. And as for, Madam President, your second point about, Madam President, could you please remind me about the other relevance of the chart that you mentioned?
I was just asking you generally what the relationship is between the part of Article 5 that speaks to the low water line and the part that speaks to the charts. I think you may have answered my question already, so I think you can go ahead.
Thank you, Madam President. And on this note, I would like to address a point made by the applicant, again, that states can simply choose whether their baselines are fixed or ambulatory. And Madam President had asked, how do states know the position of other states? Indeed, they do not know first whether other states' land had receded or expanded. They have to check it. And not only that, they do not know what the position of these other states are in relation to fixed or ambulatory. This means that a state will have to constantly check with every single other state what their legal position is, and that undermines the object and purpose of legal stability and certainty under the Convention.
Could I take you back to my questions about treaty interpretation, if I may? So there are varying arguments one could make about what we know about the positions of various states. But let's just assume that we're a few years ahead. And let's just say that, say, 140 states have indicated, have either asserted a mobile baseline or have taken the position that such baselines are consistent with the Law of the Sea Convention. So then how, under the Vienna Convention on the Law of Treaties, how does your state take stock of that growing agreement, apparently, of the parties to the treaty on a particular interpretation of the treaty?
That turns on the question of whether there is sufficient subsequent practice that establishes an agreement of states parties about the interpretation of the term under Article 31(3)(b) of the VCLT.
But the ILC has also said that partial subsequent practice under Article 32 may play a role.
So if you could address both of those, please.
I'm supplementing the President's question.
And that is true, Your Excellency, although the ILC did say in its 2018 draft conclusions that practice between a limited number of states can be considered under Article 32, although that carries less weight than that under Article 31(3)(b). And I note that the threshold of practice under 31(3)(b) requires all states parties to have either engaged in a practice, or if they did not engage in a practice, to have accepted the practice of other states. And I note that this is something mentioned in the 2018 ILC Special Rapporteur 5th report, which I know Your Excellency was Special Rapporteur of. And
it seems that you're not the only person in the room who's aware of that. But let me take you back to Article 31.
Yes.
Let's assume that we don't have any, let's leave aside the supposed persistent objector argument. Let's just assume that that's not of interest to this court. And we have a large number of states in the 140 range, and others have said nothing or, as was suggested earlier, reserved their position. At what point are the conditions in Article 31 regarding subsequent practice, at what point are those met?
If it's the situation that 140 out of 170 states parties to the UNCLOS have taken that position, then we can accept that, assuming that the remaining 30 have accepted the views of the 140, then a new understanding has been accorded to allow states to fix their baselines. But that is not quite the situation, actually, based on the submissions of states parties to the ILC. And I note that Judge Nolte had asked agent for the applicant whether there were 2 or 3 states who mentioned that this is merely something that is an emerging norm or something that is unclear. Now, there's not just 2 or 3 states. In fact, there are at least 24 states who have expressed views to this effect. And just to name a few, this includes Thailand, the United Kingdom, Cuba, Tonga, Malaysia, states in Europe like Romania, Poland, South America, Argentina, Chile.
Sorry, what was the first state you mentioned?
If I can name one state submission, for example, that of Iceland, it stated in their submission to the UNGA in 2021, and I quote, that it was too early to comment on the precise legal implications of sea level rise for the convention, end quote. And later in 2023, it stated on behalf of the Nordic states that there is an important difference between saying that there is no obligation to update the charts under the UNCLOS and equating that to saying that baselines are fixed according to the charts. This view...
Does this mean, if I accept that situation, but would the court not, if it would accept your position now, arrest a development of international law, which a large majority of states seem to be pointing to, and a small minority not really objecting to?
Well, that is an important concern if the position was that baselines were always fixed, and there's a small, troublesome minority that is opposing that position. But the reality here is that the long-standing position is that baselines are fixed. And what the applicants are seeking to do is to change that long-standing legal status quo in favor of a fixed baselines approach. Therefore, it is not just a question of a few states who are opposing, but quite a sufficient number, at least 24, as I've mentioned, that have expressed a view similar to that of Iceland, which I've cited. And to address the final points on the evolutive interpretation, I note that Judge Romez Gobledo had asked whether there is a fundamental change of circumstances here. And as the agent for the applicant has rightly pointed out, there is no fundamental change that it seeks to invoke here. The question remains whether it can rely on the change of circumstances to dynamically interpret Article 5 of the UNCLOS. But this court has set out requirements for applying that doctrine in its 2009 navigational and related rights case, including that the term interpreted must be generic. But here, Article 5 is not a generic term. In fact, it is a carefully constructed provision when seen in light of its neighboring provisions like Article 7(2), which provides for straight baselines method of drawing the baseline. That provision is important because it specifically provides for the chart recognized by the state to remain permanent, irrespective of subsequent regressions of the coast. And the presence of such an exception in Article 7(2) means that drafters had contemplated the possibility of fixed baselines, but excluded it for the purposes of Article 5. And an evolutionary interpretation would cut against that intention of states parties. Turning then to address the final issue concerning the seizure and sale of the Falcon. We agree with the applicant that the central question is who was the government of the applicant at the time. Where we disagree is on the applicable test. The applicant has submitted that the only requirement is constitutional legitimacy and not effective control. But we submit to the contrary, that effective control is the only requirement. But to first understand what is the correct test for determining the government of a state, we must begin with the purpose of such a test. And the purpose is to identify who is capable of causing a state to comply with or violate international law. And
Excuse me if I may interrupt. So what you're saying is governments in exile are irrelevant?
They are not, Your Excellency, they are not irrelevant insofar as we are concerned with the conferral of official recognition, which carries with it political and normative dimensions, as has been done, for example, by the UN's Credential Committee. But what we are concerned here with is not official.
Sorry, Counsel, are you saying that official recognition carries normative value? Did I understand correctly?
It does?
Well, then tell me, do you know about any rule of international law, either universal or regional, that gives, that obliges a given state to seek and get and obtain recognition for that state or that government? It can apply both to state and government. Is there a rule that obliges that state or government to seek and obtain recognition for that state or government to be considered as a legitimate one?
We submit that there is in fact no obligation, whether internationally or regionally, for states or governments to seek that kind of recognition, although we accept that there are elements of statehood that are well established under the 1933 Montevideo Convention, which are not in question before this court. But as for the recognition of governments,
Slovenia and Ambrosia are part of a group of states which have signed the OCDP Charter, the first article of which says that they intend to protect the rule of law and our democratic institutions. Now, even if the court would say, okay, under universal law, effective control is determinative, would we not have to say these 7 states are a democratic community and they cannot just accept the exercise of raw power and follow the exercise of raw power?
Well, Your Excellencies, I can see why Article 1A of the Charter prima facie seems to cut against the recognition of the Council. But if I were to invite this court to consider the ambiguity about the meaning of the rule of law here, and the question raised by Judge Note earlier about whether the fact of the matter is that the constitutional precedentary of the applicant state has not changed. It has not changed before the Council was established, and it has not changed during the Council's administration. In fact, the Council made it clear that once President Derry was able to assume office, it would dissolve immediately, and it did so, as promised at paragraph 55 of the facts. The other reason why I say the OCDP Charter supports the recognition of the Council by the respondent is the second part of Article 1A, as well as Article 1E. Article 1A in its second part points to democracy, which does not expressly stipulate for example, democratic processes and elections, but points to the substantial need for substantial democracy. And we would characterize that as giving effect to the will of the people or the right to self-determination, which is a right enshrined in the ICCPR, which both states are parties to. There are compelling.
You are aware that the argument of real and substantial democracy has been used and abused, and that there is a certain danger with that argument.
There are certain dangers with that argument. I note my time, Madam President.
Please go ahead and finish the answer to that question, and then your time will be up. Thank you.
Thank you. The reason why it was not used in an abusive interpretation here was because there were compelling reasons for the Council to have assumed power. Now, not only do we see that the Zavalan administration dealt with the natural disaster inadequately, and that there were violent demonstrations against her administration asking for Peretes to assume rule, we can also see that the Transitional Council did as it's promised to return the power back to Derry when it assumed office. This concludes my submissions, and may it please the court.
Thank you.